Good day to you, everyone. Thank you for joining us for our second session for today for the Norman Manley Law School Legal Aid Clinic, Legal Aid Fair. We want to welcome all of you who are joining us for this session this morning. And we are excited to be hearing the presentation entitled The Right to Counsel and the Role of Duty Counsel. This is a presentation that was prepared by the Legal Aid Council and by its Executive Director, Mrs. Dian Watson. I am Kayan Bali, and I'm one of the tutors here at the Norman Manley Law School Legal Aid Clinic. As I mentioned, the presentation this morning was prepared by the Legal Aid Council, Mrs. Dian Watson in particular. Unfortunately, Ms. Watson is unable to join us today, and so her presentation will be delivered by Ms. Dian Cruikshank. Ms. Dian Cruikshank is one of the attorneys at law, also at the Legal Aid Clinic. Ms. Cruikshank has experience for several or many years at the criminal bar and is quite able to make this presentation this morning. Insofar as Ms. Watson is concerned, just a brief introduction as to who Ms. Watson is. Mrs. Watson is an accomplished advocate with a blended background in both criminal and civil litigation. In addition to practicing at the private bar, Mrs. Watson has also served in various supervisory and managerial roles in the public sector. She is the holder of a Bachelor of Laws degree from the University of London, and she also pursued postgraduate studies at Columbia University in the city of New York, where she was awarded a Master of Laws degree. Mrs. Watson is the Executive Director at the Legal Aid Council, where she hopes to lead the transformation of the council in providing services, not only in criminal cases, but also in the area of civil law to the most vulnerable and disadvantaged persons in the society. Now, with that background, I'm sure you will all agree that we are in for an engaging presentation concerning the right to counsel and the role of duty counsel, which may be particularly important for our students who are watching this presentation, as well as those who may have been recently called to the bar as they engage in their first or early years of practice. Ms. Cruikshank will be making the presentation, and I now hand over to her.
Good morning, everyone, and welcome again to our Legal Aid Fair. The presentation this morning will be titled The Right to Counsel and the Role of Duty Counsel, and it has been presented by the Legal Aid Council. We'll begin with a historical overview of the Legal Aid Council. The right to counsel developed an evolving concept designed to meet the needs of the criminal justice systems. Locally and internationally, the right to counsel evolved with increasing access to legal aid. In Jamaica, the Poor Prisoners Defense Act was established in 1961 to provide for legal aid to be granted to persons of insufficient means, to assist them in the preparation and conduct of their defense. And that is accordance with Section 3 of the Poor Prisoners Defense Act of 1961. The nature and scope of the right to counsel. The right of an accused person to retain legal representation if he cannot afford one is enshrined in the Jamaican Constitution under Section 16C, subsection 6, which provides that every person charged with a criminal offense shall be entitled to defend himself or herself in person or through legal representation of his or her choosing, or if he or she has not sufficient means to pay for legal representation, to be given such an assistance as is required in the interests of justice. The right to counsel is also applicable to persons who are detained under Section 14, subsection 3D of the Constitution, which states, any person who is arrested or detained shall have the right to communicate with and retain an attorney at law. The Jamaican law attaches the right to counsel upon arrest. Regulation 12 of the legal aid regulation creates a duty on the police to inform the detainee of his right to legal aid and to request the services of the duty counsel if the detainee is unable to afford an attorney at law of his choice. The legal aid. We're going to look in this segment at the Legal Aid Act, the Legal Aid Council, in connection with the Justice Mobile Unit and the legal aid clinics. Now, the Legal Aid Act is a statute or law that governs legal aid in Jamaica. The act seeks to secure access to justice for all Jamaicans. It provides a system of affordable legal representation for nearly all criminal offenses. And later down in the presentation, I'll indicate to you the offenses which are not eligible for legal aid. Who benefits from legal aid? Any person detained on suspicion of or charged with criminal offense punishable by imprisonment is entitled to legal aid representation. And legal aid representation is given from the time one is being taken into custody at a police station through to bail, trial, and if the person has been convicted, through to the appeal court. And who grants legal aid? Legal aid can be granted by a parish court judge, a judge from the High Court, the registrar of the Supreme Court or appeal court, the director of the legal aid clinic, the executive director of the legal aid council, and these persons certifies and grant legal aid from the beginning to the conclusion of the matter before the court. So this now leads us once again to the services of legal aid. Legal aid is available to all persons who are suspected or charged with committing a criminal offense and who cannot afford to privately retain an attorney. The Legal Aid Council is empowered by the Legal Aid Act to provide and administer an efficient legal aid system in Jamaica. Legal aid clinics are the points of contacts for clients to access legal aid services. And there are two clinics, one in St. James, where we have the Montego Bay Legal Aid Clinic, which caters to the western part of the island, and one in the parish of Kingston and St. Andrew, which caters to the parishes in the eastern central part of the island. And I'll use this juncture to indicate to all persons that all attorneys at the private bar at some time give their services for legal aid. So persons would say, oh, a legal aid lawyer is not a good lawyer. All persons, King's counsels, all persons conduct legal aid services. The empaneling requirement for an attorney to become part of the legal aid team is to provide the following: a completed form, tax registration number, voter identification, a bachelor's of law certification, a legal education certification, call order means being called to the bar, and a practicing certificate. Those are all the requirements that an attorney needs to be part of the legal aid panel. The Justice Mobile Unit visits various communities across the island and it involves themselves in outreach programs. The legal consultant on the mobile unit is Ms. Shara K. Dakers, in the event anyone would want to be in contact with her. And this is a picture of the legal aid mobile unit. The Legal Aid Act was established in order to be the creature that created the Legal Aid Council to provide legal aid in Jamaica. Under the Act, the Council establishes and operates legal aid clinics, review policies and laws about legal aid, receive and administer funds, decides on eligibility for legal aid, that is, persons who are eligible for legal aid, establishes panels of attorneys across the islands in regards to the parishes of which the attorneys live, and pay empanel attorneys based on the established tariff of fees. So the role of counsel, what is the role of duty counsel and their legal representation in court and the exempted offenses? A duty counsel is an attorney at law who is available to attend a police station when called to do so. And the police stations across the islands have a list of attorneys and their contact details, mostly in the guard room, to contact attorneys if persons, when taken into custody, do not have the monetary source to retain private counsel. The duty counsel conducts client interviews, conduct question and answer sessions for minors and for adults, conduct identification parade, which conventional, video identification parade, dock parades, informal ID for minors. They also do habeas corpus applications, and that area of law was discussed this morning by my colleague, Mr. Hugh Wilson. When a person is taken into custody and not brought before a court, a habeas corpus application is made, bail applications, and advice of other legal aid assistance. The duty counsel also must ensure there's no conflict of representation, and in order to be remunerated, the form has to be signed by a police officer or correctional officer, and there's no cost to the client for duty counsel, and no application form is necessary. Outside of the police stations, there can be court assignments. A person may be appearing before the court and indicates to the parish court judge or the judge in the high court that they're unable to secure the services of the attorney. They don't have the means, and at that point, the adjudicator, the parish court judge, or the high court judge can do a court assignment for counsel. Once that is done, counsel has a duty to attend. Counsel has to complete the matter, and there's a procedure to notify certifying authority of absence, or if one no longer wants to be part of the matter. There are instances where counsel may decide to revoke their assignment, or the court may decide to revoke the assignment. And there is a time frame for one being called to the bar for counsel to be able to do murder matters, homicide, and gun-related matters. And if one has not attained those years at the bar, one should do the matter with persons who have attained that level, which should be deemed as senior counsel. The court assignments also extends to the children's court, which does child diversion and children deemed uncontrollable juveniles. The court assignments also extends to duty counsel engaging in expert assistance, whether it's the DNA or DNA, hearing aids, expert handwritings, and the matter must be completed by counsel who has been assigned to the matter. And completion means either being acquitted or the matter being adjourned sine die, or there's a sentencing or dismissal for want of prosecution, or if death occurs. of the accused. The exempted offenses, according to the Act, the only offenses for which legal aid is not given currently are the Dangerous Drugs Act, namely for manufacturing, importing, taking preparatory steps to export, selling or otherwise dealing in any dangerous drug, and being in possession in excess of the specified amount. Other offenses, the Money Laundering Act, which has been repealed, which has been replaced by the Money Laundering Provision Act, placed in the Proceeds of Crime Act, otherwise called POCA, which that's the abbreviation. And so legal aid is granted for money laundering and law reform, fraudulent transactions, Special Provision Act. Any offense not punishable with imprisonment is not eligible for legal aid. Petty session offenses such as threatening, abusive, and calumnious language, resisting arrest, assaulting a constable, abusive language, obstructing a police, disorderly conduct. Legal aid is granted to children for all petty session matters. So how does one get legal aid? There's a procedure, and how does one become part of the legal aid system? So for persons, once they have been called to the bar in the jurisdiction of Jamaica, in order to be eligible to be part of the legal aid panel, there are forms that you have to fill out: A, B, C, D, and E, application by an attorney, report and certificate of due to counsel, bill for legal aid services rendered, application for legal aid under the Legal Aid Act, and the legal aid certificate. So for persons to, once an attorney is empaneled on a matter, they have to, E is the bill that they send in for legal aid services. C is an application for legal aid under the Legal Aid Act, which is normally filled out by the court's office. D gives, at that point, the court's office then issue a legal aid certificate. And all those have to be handed in for counsel to get paid. The fees for counsel who performs legal aid is dependent on whether it's a parish court matter, a circuit high court matter, or whether it's an appeal. And also, if the trial is concluded, whether adjourned, sine die, the client dies or absconds. And with all things that we do as professionals, there's ethics, which we cannot leave out, which is an integral part of counsel in the practicing of law. Ethics and the profession, ethics of canon, maintain the dignity and integrity of the legal profession when conducting legal aid matters, or any matters for that matter. No unauthorized, improper, or unprofessional practice. Duty to public and duty to state, and persons must always ensure, first and foremost, as counsel, you're an officer of the court. Honest representation and the interest of the client is paramount. So best interest of clients, duty to uphold the dignity of the court's administration of justice, proper professional attitude towards fellow attorneys, and maintain proper accounts. Duty to counsel remain at all times the detainee's attorney. Duty to counsel is not the police representative. So even though the police calls you and invites you to the police station on behalf of the person in custody, your interest and your loyalty is to the detainee. The detainee is entitled to his attorney's full protection, and all ethical and professional considerations apply in your relationship with your client. And I will continue to reinforce the interest of your client is paramount. The client provides instructions to the attorney Always meet with the detainee privately outside of the hearings of the police before you undertake any work on his behalf. And I'll take this time to say all that you speak of and all instructions must be taken in writing, read over to your client, and have him or her sign it. Never act for a detainee unless you have first met with him or her and advise him or her of their rights. Advise him of his rights to choose his own attorney. The accused detainee retains the right to choose an attorney of his or her choice. It is also important to tell the accused person that he's entitled to have the process which the police contemplate, question and answer, identification parade postponed to facilitate the attorney of his or her choice. Advise the accused person of the nature of the process he is to undergo and his rights in relation to it. Be sure to advise him of his rights against self-incrimination. Additionally, I will add, ensure that they understand all of what you are saying, and be also mindful to explain it in a manner that they will understand. Legalese is not necessary at this point. Please ensure that the person is not exposed before identification parade and must be cautioned before a question and answer. Take instructions as to his treatment when he's first detained and since he or she has been in custody. Duty counsel must ensure to check on the following. Is the detainee a child? And if the detainee is a child, they need to be with their guardian when they're being questioned by the police. Is detention in accordance with the law? Was he or she beaten? Make your own observation of signs of bruises, cuts, swelling, or other signs of beatings. Was he or she threatened? Was he or she exposed to the public, even though he or she is to face an identification parade? Has he or she given a written or oral statement to the police when? Have samples been given of handwriting or bodily samples? Was any clothing submitted or taken from the accused, or other property taken from the accused? Ascertain the name of the police who came in contact with the detainee, which is the arresting officer, for future reference. Duty counsel's claim only for person in custody. One duty counsel claim per suspect, and this is for counsel, and each separate unconnected offense is treated as another matter and claimable for fees. Advising the client. You're called by the police to attend the station to assist John Lee suspected of raping a young woman. On your arrival, you see John lying on a bench in the guard room. He's handcuffed to this bench. He does not get up when you introduce yourself and immediately tells you he knows nothing about the rape. He is stressed out, sad, and confused and starts to cry uncontrollably. How do you deal with this situation? And this is something I will leave with you to discuss with your colleagues. And the sources here are the sources that was used for this presentation. At this time, it comes to the end of the presentation. If there are any questions, comments, I will be more than happy to take them.
Thank you, Ms. Cruikshank, for delivering that presentation on the right to counsel and the role of duty counsel. I am looking at the chat and I see one question which has been posed so far. It's what age range is considered to be a child?
A child is considered between 10 years and 16.
Thank you for that response. That question was posed by Ms. Shanice Campbell. I'm not sure if there are any questions from your live audience.
Not at this time. But I'll use this juncture to say that any questions that come up during the course of any time can be directed to the Legal Aid Council or to myself at the Norman Manley Law School Legal Aid Clinic. Thank you, Mrs. Bally, for having us this morning.
Before you go, because we're not quite finished at the description, in relation to the scenario that was posed at the end of your presentation, do you have any guidance that you could give us, or how would you approach the situation for the benefit of the students who may be watching on the platform?
Okay, we'll go straight to that. Thanks for that, Mrs. Valley. So let me read it again. You're called by the police to attend the station to assist John Lee, suspected of raping a young woman. On your arrival, you see John lying on a bench in the guard room. He's handcuffed to this bench. He does not get up when you introduce yourself and immediately tells you he knows nothing about any rape. He's stressed out, sad, and confused and starts to cry uncontrollably. How do you deal with this situation? Firstly, the person who invited you to the police station, you would then, first thing you need to do is ask for the station diary to see the condition that Mr. John Lee came into custody. What brought him into custody? Did somebody go to the station to make a report? What was it that brought Mr. John Lee into custody? In addition to that, we need to, it doesn't say by the scenario John Lee's age. If John Lee is a child, that means he's a minor. His parents would have to be contacted before you can engage in any interview with John Lee. You need to find out from the because at this point, based on how they are indicating that John Lee is behaving, you need, before you decide to calm down John Lee, to see whether he suffers from any mental challenge, the age group, and the circumstances. And this should be placed, this information I would have hoped would have been placed in the station diary. Once you have tried to ascertain this basic information, and if John Lee is of age, then you try to calm down John Lee and indicate to John Lee that you have been invited to the police, you're due to counsel, you're here on his behalf, not on the behalf of the police, and you're here to assist him. Indicate to him, first you find out with him if he has a, has a challenge with you representing him after you have explained yourself. If he says he doesn't, then you can proceed now to ask John Lee, what has happened. But then before that, you'd have to find out from the investigating officer, why was he handcuffed to the chair? Because that is important. Because when a person is taken into custody, they are innocent until proven guilty. So he's only a suspect. Hence, and even if he's charged, if he's in a room in which, within a police station, he really shouldn't be handcuffed in a manner as stated there. Why is he not sitting? Why is he lying on the bench? So all of that you'd have to ascertain as to why the officers chose to use that approach in the detention of Mr. John Lee. How long has he been there? Why has he been handcuffed? If his family has been notified, all of that you need to ascertain before you even start the interview with Mr. John Lee. And what is it that brought Mr. John Lee into custody?
Okay, thank you for that very valuable insight, Ms. Cruikshank, on what is to be done in such a scenario. I would invite members of the public who are viewing at this time to indicate in the chat if they have any other questions or comments, whether related to this specific scenario or otherwise. I will allow them a few moments to do so. But until then, I have a few other questions to ask, one of which involves the question of payment for duty counsel. Is there a schedule or a set period of time within which persons are paid fees for the work that they do as duty counsel?
There's a fee list, a tariff fee list, and that is based on your years at the bar and also based on the type of matter and based on whether if you're doing the matter with someone senior to you or junior to you, the tariff of those fees can be seen by the legal aid counsel. The legal aid counsel tries their utmost best to pay fees to counsel in a reasonable time. Many times they're not that able to do so, but they make every effort to pay fees within a reasonable time.
Thank you, Ms. Cruikshank. A further question, do you have any comments on your presentation treated with counsel in the context of criminal matters? Is there any plan afoot to extend legal aid services to civil matters of which you are aware?
Yes, currently the matter is, as you indicated, Mrs. Bally, it's primarily criminal matters. However, they are seeking ways in which to have these matters extended to civil matters.
Thank you for that, Ms. Cruikshank. I'm not seeing any further questions or comments being included or placed in the chat. I want to invite one of our students, I'm not sure if she's on the platform, Ms. Christy Lopez at this time, to move the vote of thanks. Ms. Lopez.
Mrs. Bally?
Yes?
It was a pleasure for me to deliver the presentation of the Legal Aid Council, as my senior and father of blessed memory was once the executive director of the Legal Aid Council. So it gave me great pleasure to deliver this presentation on behalf of the Legal Aid Council and on behalf of the executive director, Mrs. Dian Watson.
And we do appreciate you for having done so, Ms. Cruikshank, and you come from, well, as they would say, good pedigree or good stock, insofar as the legal aid system is concerned. And so we are grateful for the insights that you provided, even as you made this presentation on behalf of Ms. Watson, Mrs. Watson, who, as we indicated, was unfortunately not able to join us for today's presentation. I am still not seeing any further questions posted in the chat. And I'm not sure whether our student is on the platform. Since I'm not seeing her, I must take this opportunity to say thank you, Ms. Cruikshank, for coming in almost at the last minute to make this presentation on the right to counsel and the role of duty counsel. It certainly was an insightful presentation, and it also provided, I think, particularly our junior practitioners with the steps that they can take. First of all, to be listed as duty counsel with the Legal Aid Council, and as well what their role is or what steps they are to take when in fact they are called upon to become advocates for persons who have been detained in police stations. Thank you again for participating and for sharing with us today.
Thank you very much, Mrs. Valley.
This concludes our live stream events for today, Tuesday, January 10, day 2 of our Legal Aid Clinic Fair. Please join us tomorrow, Wednesday, January 11 at 9 a.m. for day 3 of our week of activities. For further information about the Legal Aid Clinic and the services that we provide here, please visit our website at nmls.edu.jn, or you may email us at nmls.lac@uwimona.edu.jm. We can also be contacted by WhatsApp at 876-561-9803. Thank you for joining us, and we look forward to seeing you tomorrow morning at 9 a.m., where we will have presentations treating with the expungement of criminal records and also questions arising from possession of marijuana. Is it illegal? And how much is too much? We will see you then.